Okay, I think we can slowly start. Good afternoon and welcome everyone. I think we will have more who will be joining shortly, but let's stick on time. I am Yasemin Çetinel. I currently chair SCL Turkey, for those who do not know me. And I will be moderating this very interesting webinar today. As SCL Turkey, we are very excited to host yet another very specific event for our audience, for our colleagues, and for our members. What we will delve into today is the sanctions issue, and specifically the sanctions related to Russia this time. And we have an excellent panel of speakers, panelists, and I would like to very briefly introduce them to you before proceeding with our panel and the presentations. First of all, we have Tal Magnus joining us today. She is counsel with specific focus on US export controls and trade sanctions. Our second panelist is John Barker, and his practice similarly, of course, focuses on national security matters, including export controls, trade sanctions, as well as the compliance with the Foreign Corrupt Practices Act. Third panelist today is Goran Utrisa. Goran provides strategical, practical policy advice across a range of issues at the intersection of law and policy as part of international arbitration practice. Finally, we have Ayşenur Şanlı Kıncal, our fourth panelist. And Ayşenur's practice concentrates on international commercial and investment arbitration, as well as economic sanctions and compliance matters. So that's really a very distinguished panel. We are very happy to have you. Welcome again, and we are very happy to proceed with the panel as well. So just very brief introduction to the issue on how we will elaborate today. We divided the issues into 4 subtopics, and very briefly to put, we will first cover when do US sanctions apply, which will probably get your attention, hopefully get the most of the attention. And then we will elaborate what are the US sanctions that, come into the table when the jurisdictional issues are once done. Then we will also elaborate the EU sanctions. And finally, we will deal with the enforcement issues, enforcement of these sanctions, and some practical tips on the matter. So we will have first presentations first on each of those subtopics. And after finishing the presentations, we aim to have around half an hour for the general Q&A session, where you can directly ask questions, either raising hands or just putting your question into the question and answer part, or even into the chat part of the webinar, as you prefer. Lastly, just for the housekeeping issues, we will be circulating the presentations after the webinar. So you will have the notes of the panelists that they gathered before this webinar, and it will be emailed to your emails. And without further ado, I should really pass the floor to our panelists, and I think it will be Tal who is going to speak first, and with the when do US sanctions apply subtopic. Tal, the floor is yours.
Thank you, Yasmin, and welcome everyone. We're happy to be here, and I'm going to dive right in because there's a lot to cover. So as Yasmin mentioned in the introduction, the first topic that we are going to cover today is when do US sanctions apply? So basically that question is, when do I need to think about US sanctions, or under what circumstances do US sanctions apply to me? That's the first topic that we'll cover. So the way that we talk about those questions in the world of US sanctions laws is through a term called jurisdiction. And jurisdiction basically means the circumstances in which the United States government has the power to impose its laws and basically require you to comply with them. So depending on the type of sanctions that we're dealing with, the rules of jurisdiction will be a little bit different. And if we could just go to the next slide, there are essentially two main categories of US sanctions laws, and we'll get into the substance of each more throughout the hour, but I mentioned them now because jurisdiction, as I said, operates differently for each of these two main categories. And the first category is primary sanctions. And for primary sanctions, you're required to comply with primary sanctions only when there is US jurisdiction. And so only when the circumstances involve some type of connection to the United States. And again, we'll get into this more in the next few minutes, but this is basically when there's a US person involved or some other US nexus. It can also extend and apply to non-US persons when there is a US nexus, even if the activity is taking place outside of the United States between non-US persons. Primary sanctions are primarily handled by the US Treasury Department, the Office of Foreign Assets Control, or OFAC. And then, as I mentioned, there's another type of sanctions where jurisdiction is a little bit different. That's secondary sanctions. And the United States can enforce its secondary sanctions laws even when there's no connection to the United States at all. So these are extraterritorial sanctions that are designed to discourage non-US persons from engaging in certain transactions, even if the transaction has no connection to the United States at all. Secondary sanctions are enforced by OFAC as well as in addition to the United States State Department. So I think we can go to the next slide. So taking a step back to returning to primary sanctions, I'll go into a little bit more detail on when the United States, has jurisdiction in the context of primary sanctions. So again, here we're talking about the circumstances in which the United States has the power to require all of us to comply with primary sanctions laws. So first and foremost, the United States has this power. It requires all US persons to comply with primary sanctions laws. The term US persons is probably a little bit broader than you might think. And in fact, that'll be a theme throughout this topic, that the jurisdiction is a lot broader than we might think. So even though there needs to be a US connection for the United States to have jurisdiction, there are a lot more types of US connections that are sufficient to trigger jurisdiction than you might think. So up on this slide, we have each of the components of the definition of US person. This includes US citizens, permanent residents, wherever they are in the world. So if I am doing business in Turkey with other non-US persons, the sanctions still apply to me because I'm a US citizen. I have to comply wherever I am in the world. They apply to any person that's in the United States, regardless of nationality. So if you're a Turkish citizen working from New York for one particular week on a project that is based in Russia, the sanctions will apply to you while you're in the United States, regardless of your nationality. In terms of entities, primary sanctions apply to any entity that's located in the United States, any entity that's organized in the United States, and non-US branches of entities that are organized in the United States. In some sanctions regimes, US persons is even broader than that and applies to subsidiaries of entities that are based in the United States. We can go to the next slide. So there's also a concept in US sanctions laws called facilitation. It's a way, another example of the sanctions operating a bit more broadly than you might think. It basically says US persons cannot approve, finance, facilitate, or guarantee a transaction by a non-US person if that US person can't do it themselves. So for example, this means that a US person can't draft a contract for prohibited business involving a sanctioned Russian company, even if that US person isn't really part of the project. They can't sort of help the project at all or contribute to it. Next slide. So now we move on to when do primary sanctions apply to non-US persons. So I said before the sanctions always apply to US persons, and we went over that definition, but importantly, it's not only US persons that need to comply. There are a number of ways in which non-US persons may also be required to comply with primary sanctions laws, even if the activity is between only non-US persons and it's outside of the United States. So if there's any US nexus involved in the activity that you're undertaking, that can bring the activity within the jurisdiction of the United States. And these, the nexus that can bring non-US activity into jurisdiction is very broad again. So if you have any US person involved, including a US financial institution, most dollar-denominated transactions will be subject to US jurisdiction because they transit through the US financial system. If you route any activities through the United States, for example, IT and data processing, even if you use a US-based email server, for example, that could bring all of your activity within the jurisdiction of the United States. And one of the broadest categories is if your activity includes or uses any US goods, software, or technology. We'll get into this a bit more later, but that is also a US nexus that would allow the United States to require you to comply with US sanctions laws. Another really broad concept in this area is the concept of causing a violation. So non-US persons are prohibited from causing a US person to violate US sanctions laws. And we have an example on the next slide that will illustrate how broad this is. So this is an example of an enforcement action that OFAC took against an entity that's based in Singapore called CSE Transtel. So CSE was dealing with Iranian companies to deliver and install telecommunications equipment in Iran. So this is activity between two non-US parties, and it's the activity is based outside of the United States. However, CSE transferred funds related to this business denominated in US dollars. So the funds were processed through the United States, because with most dollar denominated funds, even if you're using non-US banks, at some point they'll hit the United States financial system through a correspondent or intermediary bank for currency denomination reasons. So OFAC determined here that CSE caused financial institutions in the United States to be involved with basically a prohibited transaction involving Iran, and CSE had to pay about $12 million to settle the case with OFAC. So this is a really good example of a non-US entity sort of falling into the jurisdiction of the United States and being required to comply with US sanctions laws because of a pretty tenuous US nexus. And this happens very frequently. It's a very common way that OFAC will exercise jurisdiction over its sanctions laws. Next slide. Another really important and broad area in terms of jurisdiction, as I mentioned before, is that when your project or activity deals with US origin goods, technology, or software, that can also be a sufficient US nexus to bring otherwise extraterritorial activity within the jurisdiction of the United States. So here we talk about items that are, the term that I'll use is items that are subject to the US Export Administration Regulations, or the EAR. And that basically means that the items fall into a set of regulations that are the US export controls that are contained in these regulations. And any items that are subject to the EAR, and we have the definition up here, all the types of items that would fall into this category can create US jurisdiction. So if you're dealing, as I said, with US origin items, that will be an item subject to the EAR and can render all of your activity subject to US jurisdiction. It's not just US origin items, it's also non-US made items that incorporate a little bit of certain types of US origin components or technology. This can get really complicated, and we'll talk about US export controls a little bit in the next a little bit more in the next segment. But right now, the point is that this can be a way that that activity that's outside of the United States, yet another way that can make it subject to US jurisdiction. Next slide. So as I mentioned at the very beginning of this, we have primary sanctions laws, and then there's also secondary sanctions laws. And in the context of secondary sanctions, the United States does not need to have any of these connections to the United States in order to enforce them. They apply, and the United States can enforce them when there's absolutely no US jurisdiction. So they apply to non-US persons, and one of the most common types of secondary sanctions that exist are basically the United States putting you on a prohibited party list. There are specific instances when the US will exercise secondary sanctions, and for our purposes, I'll say that there's a substantial risk of imposition of secondary sanctions against any entity that is helping the war effort by Russia against Ukraine. So one example could be construction projects that support the Russian military. So in that case, even if all of your activity is outside of the United States, between a Turkish company and a Russian company, if it's supporting activity that the United States deems really bad, it could add you to a prohibited party list or deny you access to the US markets, that sort of thing. And I think that's the last slide on our section on jurisdiction, and that Aisha is going to add some thoughts here.
Yes, Ayşenur, please go ahead. I will anyhow turn to you for your comments.
Okay, thank you, Tol, thank you, Yasemin. During my current practice in Turkey, I observed that there is a common misunderstanding that the US sanctions apply only to the US persons. The understanding here is that I'm a Turkish person. My company is based in Turkey. I'm only bound by Turkish laws. That may be true from the Turkish law point of view. However, as Tal explained, the reality is not like that from the US law perspective. So our audience here, if they do business in connection with Russia, they must be very well aware that they may be exposed to not only secondary sanctions, but also primary sanctions under the US laws, as they may be considered as a US person, or even if they are not considered as a US person, there may be a US nexus creating the jurisdiction of the US authorities. And to tell you frankly, that creation of the US nexus is fairly simple. It might be surprising to the audience, but using a US software like video streaming software like Zoom or WhatsApp, or I don't know, using Gmail, because the servers are in the United States, that may create the nexus. So to this end, I recommend that the companies make their own risk assessment to identify all the nexuses with the United States to make sure that they comply with the US laws. Thank you.
Thank you. It's quite a striking introduction to the matter. So, more or less everything may be included in the US nexus by the examples given, because we, on an everyday basis, use WhatsApp, I don't know, Teams or Zoom. Even now, we are in Zoom in our webinar. Just perhaps, if I may ask, now that I have it in mind, one or two questions, and of course, open to the whole panel. Immediately, I thought about the dual citizens. As you know, between Turkey and US, there are some people that have dual citizenship and that are US citizens as well. And these people may be in managerial positions in Turkish companies. So how does this impact them and personally, and their transactions that they do on behalf of the company as well?
Sure. So Yasmin, why don't I take why don't I respond on that? So it's a very good observation, because we have many close interactions between Turkey and the United States, And so it's quite normal that we have board members or senior management officials who might be US citizens, dual citizens. They might also be what we call US permanent residents. In the United States, we sometimes call them green card holders. So they might be a Turkish citizen with a US permanent residency. And the US takes the position that there are certain benefits of being a US citizen or a US permanent resident, and with that comes certain responsibilities. And one of those responsibilities is to follow US sanctions and to abide by US sanctions regardless of where you're located. So the bottom line is the US is kind of tough on this. It might be, you might almost say, a little bit obnoxious. They say that if one takes upon the benefits of being a US citizen, one has to also take on the burdens of being a US citizen. Now, just because you have a US citizen board member or a US citizen senior manager or a US permanent resident in one of those positions, it doesn't mean that the company is automatically subject to sanctions, but the actions of the individuals would be subject to sanctions. And essentially, they're not allowed to do anything that are contrary to sanctions. They may need to recuse themselves, to step back. And recusal means, under these concepts in US law, you can't do anything. You can't say, oh, I'd like my deputy to handle it. Oh, or I'd like somebody else to handle it. You just have to step back. And if one does that and does that in a very honest way, truly not being involved, not what we'd say in the United States, kind of a wink that you're not involved, but truly not involved, then that's a possible way that the US citizen or the US permanent resident could protect themselves, and it wouldn't subject the Turkish company to US jurisdiction.
Thank you very much. Well, that was exactly not my question intended, indeed. And maybe just almost as a follow-up question, and I'm sure that we will have a lot of relevant questions, but then how does it work between non-US companies? For example, is there a way to kind of assign contractual obligations from a non-US company to another in order to kind of not to be within the jurisdiction of the sanctions, or not? Again, for everyone to reply.
Natalia, you want to pick up on that one?
Sure. So I think, as with most sanctions questions, you always want to look at the specific facts that are involved. So you'd want to look at closely why that non-US company is subject to jurisdiction to begin with. So, for example, if the non-US company is subject to your US jurisdiction because of the issue that we just talked about, for example, there are US citizen managers or directors that are involved, and recusal is not an option, or the company doesn't want to have to deal with recusal. There are some potential issues with that non-US company just trying to give the business off to another non-US company because of the issue that I raised briefly in the introduction, which is facilitation. So those US managers, directors can't ask another non-US company to do the activity for them because they couldn't do it themselves. So you have to be pretty careful about not implicating that prohibition on facilitation in this context. But again, there might be some facts that would operate differently in some ways to do that wouldn't implicate the facilitation provision.
Okay, thank you very much. And perhaps now is a good time to actually learn what are these sanctions and how do they operate. So if I may give the floor, I think, Tal, again to you. We can go to the other subtopic.
Great. Yeah, so next we just wanted to cover certain of the key specific restrictions that are part of the current US sanctions program against Russia. So before I get into some of the specifics, I'll just say that the sanctions program involving Russia is right now probably the most complicated sanctions program that's in place within the United States. It's not it's not a full embargo of Russia compared to embargoes the United States does have in place with respect to other countries like Iran, Cuba, North Korea. Instead, there are a lot of different restrictions that have been put in place one after the other. So it's important to understand that the sanctions program against Russia has a lot of different components. It's not only list-based sanctions, for example, it includes a lot of different components, and we have listed on the next slide a handful of the different key substantive provisions that are part of this sanctions program. So there are embargoes of specific regions in Ukraine, not Russia, as I mentioned, but that's an important component of the sanctions program against Russia. There are list-based sanctions, which we'll cover. There is a ban on new investment in Russia, a ban on certain specific types of services to any person or entity in Russia. There are these export controls that I talked about that prohibit any US goods, technology, or software going into Russia or even within Russia. And then, as I mentioned earlier, in the last segment, there are also secondary sanctions for anyone that might be imposed for anyone that engages in quote unquote significant transactions with Russian parties that are already sanctioned or also in the context of certain energy related transactions. So if we go to the next slide, we'll start to talk about these areas in a little bit more detail. So as I mentioned, the first category we'll talk about is our embargoes. So there are embargoes that the United States has put in place with respect to specific regions in Ukraine. So there are 3 regions in Ukraine that the United States has said basically nothing can happen with those regions. So no, it's all investment is prohibited. The importation of any goods, services, or technology is prohibited. The exportation of any goods, services, or technology from those regions is prohibited. There are limited exceptions, but they're really pretty limited. And so essentially, the point here is if there's any U.S. nexus, you probably can't deal with those regions. You can't engage in any activity that involves those regions. Next slide. So the next important component of the U.S. sanctions laws involving Russia is list-based sanctions. These are the most expansive and probably the most well-known type of category of sanctions involving Russia. They target Russian government officials, financial institutions, corporations across a variety of sectors, quote unquote oligarchs, and much more. So basically, the United States identifies a party that it determines is contributing to the situation in Ukraine, which is, the basis of the whole sanctions program, and places that party on one of several restricted lists. The most restrictive list that comes up in this area is OFAC's. It's called the Specially Designated Nationals and Blocked Person List, or the SDN list. And for any person or entity on the SDN list, U.S. persons are prohibited from engaging in any transactions or dealings with that SDN, either directly or indirectly. And as we just talked about in the last segment, non-U.S. persons are also prohibited from engaging with SDNs in the circumstances that we discussed before. Any of these circumstances where there's a U.S. nexus, some connection to the United States. A couple of other important points about list-based sanctions. First of all, there are some lists that are less restrictive than the SDN list. We have an example up here, the SSI list. And for the SSI list, there's the prohibitions are really about debt and equity. And they say that if a party's on the SSI list, excuse me, you cannot extend credit of more than 14 days maturity to that party. So it's a lot more narrow than the SDN list. Some activity is still allowed with SSIs. You just can't implicate this debt or equity prohibition. And one of the ways that this comes up very frequently is if you're dealing with an SSI and you issue an invoice to that SSI that says you must pay me in 14 days, and if that SSI does not pay in 14 days and you let them have extra time to pay the invoice, that can be viewed by OFAC as an extension of credit to the SI, and you will have implicated that prohibition. So the second point I just want to make about these list-based sanctions is that sort of just like in the context of jurisdiction, actually, an SDN is the SDN designations are actually much broader than they might seem because of this rule called the 50% rule. And OFAC's 50% rule basically says that any entity that is 50% or more owned by one or more SDNs is also treated by law as an SDN. And this also applies to SSIs. The 50% rule can also impose the SSI designation on an entity because of ownership. So basically, suppose there's a Russian contracting company that you are considering hiring as a subcontractor. And before hiring this company, you check to see that if they're on the SDN list, you search the name and they're not on the list. Because of the 50% rule, you actually can't stop there. You also need to check the owners of that subcontractor. And if the subcontractor is 100% owned, for example, by a Russian oligarch that's on the SDN list, that subcontractor itself is also considered an SDN. And all of the restrictions that would apply to the Russian oligarch that's the owner of this company would also apply to the entity itself, even if the entity is not popping up when you do your search against the SDN list. And last point here, we just want to mention all of these lists, the SDN list, SSI list, are updated quite frequently, especially in the context of the Russia sanctions. They're updated, they can be updated on a daily, weekly, monthly basis. So it's important to check it frequently for any updates. We can go to the next slide. So beyond these region-specific embargoes and list-based sanctions, the US sanctions involving Russia also includes an investment ban. The prohibition is quite broad and says that US persons are prohibited from making new investment in Russia. And as with other types of sanctions, non-US persons will fall into this restriction too if there's any type of US nexus or the investment would otherwise be causing a violation by a US person. So OFAC has provided a definition and some guidance on this, which limits its scope somewhat. New investment includes, it's basically the commitment of capital or other assets for the purpose of generating returns or appreciation. So it's basically committing capital anywhere within Russia. And it doesn't include maintenance of an agreement that existed before the ban. So if a project was started before the ban went into place, you're allowed to continue working on that project. You're just not allowed to expand it in any way. Under the same authority that the investment ban was issued, the United States government can also identify any specific categories of services that are prohibited. Right now, one area that has been designated is the provision of accounting, trust, and corporate formation and management consulting services. Those types of services are also not allowed to be provided to anyone or any entity in Russia. Next slide. So the final category of substantive sanctions that we just wanted to cover in this segment are export controls. And export controls are a major component of the US sanctions program against Russia. The United States, through the United States Commerce Department, requires an export license to export many items that are subject to the EAR to Russia, or even to transfer such items within Russia. An export license is required for a lot of different types of goods, technology, and software. Whether an export license is actually required depends on a host of different factors, including things like the end use of the item, the end user of the item, where the item is being shipped from. So the restrictions might not apply, an export license might not be required if an item is being sent from the United States to Turkey, but they would apply if the same item was being sent from the United States to Russia. So just because you have an item that's subject to the EAR doesn't necessarily mean that a license will be required, but it's very important to check each step to make sure that you're not required to have an export license when sending goods to Russia or even transferring them within Russia. I'll also just mention that the current scope of export controls involving Russia are very broad. As I mentioned, they capture a lot of different goods, more than most countries in the world, and even the least controlled items under the EAR, the term that we use for them is EAR 99. The least controlled items, even some of those EAR 99 items require a license to go to Russia. And the items that fall into this category span items used for energy product, industrial items, for example, bulldozers of many types will require a license to go to Russia, certain types of luxury goods. All of these items, if they're going to a military end user or for a military end use in Russia, will definitely require a license. But even for some civil end use uses, a civil construction project, they could also require a license to go to or within Russia. Whether your item will be subject to the EAR and whether it requires a license is a very sort of item and fact specific inquiry. But suffice to say that this is a very broad restriction that exists and very important to check as you're considering doing business or doing business within Russia. And I think with that, Aisha might also jump in here and speak about some of the prohibitions that we just went over.
Okay, thank you. Although the Turkish companies may have contracts with non-sanctioned entities in Russia, during the performance of the contract, I wanted to highlight that they may still very well hit the SDNs, like the banks of your employees for salary payments. The banks of your customer, your suppliers may very well be listed on the SDN. So your main contract may be with a non-SDN, but during the performance of the contract, you may still hit the SDNs. And also payments to the government should also be carefully handled. I want to add that, that's also a common misunderstanding in Turkey that the, sanctions are only about the SDNs. That's not true. And although it's very important, that's not the only part of the sanctions. A new investment ban and the ban on certain services may be very relevant to the audience because certain construction contracts may include also some sort of management consultancy services, which is not only construction on the site. Also, export controls are very important for the construction companies to take into account. Your materials, machinery, equipment may very well be subject to export controls. And the recent export control regulations about Russia have caused significant, actually, supply chain disruptions, which ultimately cause significant time and cost impacts. In certain cases, the export control regulations made the performance impossible since the item simply cannot be exported into Russia, or even not only Russia, if your item is destined to Kazakhstan or Kyrgyzstan, and if you need to use the Russian routes for the transit, you may still be in need for a license from the BIS, and that may also become impossible for the contractors to perform certain part of the services. So that may have a huge impact on the contract schedule and the cost. To this end, as a practical matter, I recommend that the construction companies, number one, must give consideration to the factual circumstances including whether the materials, equipment, or machinery which they will use to perform the contract are whether they are subject to export controls and other risk factors such as delayed programs, material shortages, and increased shipping costs. And number two, the companies must conduct a detailed review of the contractual provisions that govern the agreement between the parties and which sets out what happens and who bears the consequences of the risk factors established in the first part of the review. A similar analysis must be made during the tender preparations, and the risks especially about the export controls must be allocated and priced accordingly in the contracts. Thank you.
Ayşenur, thank you very much. You already answered a question that I wanted to raise, but I have another very small question before proceeding with the next topic. I'm aware of the time and the limitation we had. I have many other questions, but immediately after hearing about the new investment ban, I'm thinking about the difficulties in actually managing the actual contracts. So before the investment ban was applicable. So for example, what will be the regime, or if any, applicable in case of an existing contract before the investment ban has some variations, and variations being very debated matter of construction law in any event. I really wondered how the sanctions regime would approach to that. Is it a new investment? Is it the continuation of the old investment? So how would we reply to that? Again, for the whole panel.
So why don't I jump in on that? So look, it's a really good question, and it's something under US law, it's very, very fact specific. So just as the world has changed dramatically since February of last year with Russia's invasion of Ukraine, so too is the application of US sanctions. There was not a US investment ban in January of last year. A year ago, we wouldn't have needed to have this panel last year, or at least parts of this panel last year. And so when the world changes, US sanctions law changes. Sometimes there is what we call a grandfathering, or a slight time period after which you can do a wind down of activities, and those are included under US law. But essentially for the Russia sanctions, those have already passed now. They're now being implicated. And so it is likely, you'd have to look at this fact specifically, but it is likely that the prohibitions on new investment would apply even if you had a contract that was put in place a year ago. There are some exceptions to that, and you'd want to go through things very carefully, but generally the US is going to look at a snapshot of what's going on in the real world now and take that into account. One other thing I wanted to do was, there are a couple of questions in the Q&A. I'm going to respond to two of them very, very quickly. One of them was, what if you've got a group company with a subsidiary in the United States and a Turkish company headquartered in Turkey? Does that automatically subject you to US jurisdiction? No, the subsidiary is subject to US jurisdiction, but it doesn't automatically make the whole group subject to US jurisdiction. But you have to be very careful and not share services back and forth. The other question was, what's the difference between an SDN and a non-SDN? An SDN is those parties, those individuals, those entities that are designated by the US that are on a list. If you're not on the list, you're not an SDN. All of us on this seminar are not SDNs. But if you're on the list, it's designated. And back to you.
Okay, thank you very much for handling the Q&As in between as well. Okay, so I think we should proceed with the next topic, and I'm sure that we will have time to debate into more detailed questions that we already have in mind. So the next topic will relate to the EU sanctions, and I think Goran will be elaborating those.
That's correct. Thank you, Yasmin. And why don't we just start with the topic. The US regime of sanctions and the US regime of prohibitions is not the only thing that our audience, other Turkish companies and other non-US companies need to be aware of. And in this section of the webinar, we wanted to briefly refer to the regimes that were put in place by the European Union and the United Kingdom. We will just be putting up 2 slides to sort of guide our presentation. And we've put on the first slide actually a note that there is a great level of coordination between the US, the EU, the UK, and the other G7 countries in how sanctions are designed, how sanctions are introduced and when they're introduced, and how these sanctions are implemented. This makes my job today easier because I don't need to repeat everything that Tal, John, and Aisha have said before, because a lot of the concepts and a lot of the approaches that you've heard about the US sanctions actually apply to EU and UK sanctions. The European and British sanctions between themselves are very similar because they developed as one system, as one regime prior to the UK's exit from the European Union in 2020. This level of coordination is reflected in determining when sanctions apply. So as you will see on the slide, EU sanctions and similarly UK sanctions will apply within the territory of the EU. They will apply on aircraft or vessels that are under EU jurisdiction, and they will apply to EU nationals and EU companies wherever they are located. This coordination and these similarities are visible in the types of sanctions that the EU and the UK apply. So at their end, you will also have individual sanctions that take the form of travel bans and asset freezes, and you will have trade sanctions that take the form of export restrictions, import restrictions, and a ban on the provision of certain services to Russia. And thirdly, and certainly most importantly, there's an unprecedented level of coordination between the Western countries, if we can call them that way, that we have seen in enforcing these sanctions, in making sure that individuals and companies actually respect them, or if they don't respect them, that they are fined or that they are punished. And a good example that we listed on this slide is actually the establishment of REPO, which stands for the Russian Elites, Proxies, and Oligarchs Task Force. The task force was established in March 2022, and its mission is to better coordinate the G7 countries and Australia in finding, restraining, and ultimately confiscating and forfeiting assets of sanctioned Russian individuals and entities. In its first 3 months, it succeeded in blocking $30 billion of assets of Russian entities and $300 billion of assets of the Russian central bank. You can see it from statements of high-ranking officials of the US government, of the EU, and at the highest level of the British government, that these partnerships are only likely to expand. This means that the maneuvering space for those that are on the sanctions lists is becoming narrower. There is less possibility for evasion. And at the same time, for companies that still have Russia-related business, this means that it is very important to comply and that it's very important to be aware of the restrictions that are in place. We now covered some of the similarities between these regimes, but of course, these regimes are distinct, they are independent, and they have their own sets of requirements. So what we actually put on the next slide are some of the differences between the regimes that one needs to be aware of. First, actual designations, actual individuals and companies that are sanctioned are different. Countries have their own reasons, countries have their own policies, their own approach to sanctioning certain individuals and entities. So we have seen over the past just under a year that some Russian financial institutions and their owners were placed on UK sanctions lists, but then it took a few months for them to be placed on EU lists and US lists. And we have seen the opposite being true as well, which makes it very important to be aware that no assumption, makes it very important to make no assumptions about the fact that someone who is on the US list is actually on the UK list, or the other way around. A second thing to be aware of are the actual substantive prohibitions that exist. Because of the geographical particularities, the EU has prohibited Russian road transport operators from entering and transiting the EU. So we see that if there are construction contracts, if there are construction services that include road transport, irrelevant of what is actually being transported, which is an additional layer of worry for anyone involved in that contract. This is something to be aware of. And the second point we actually added on the slide are the types of banned services. You've heard previously that the US has decided to ban the provision of certain services to Russia. The EU has done the same, but for example, and very interestingly, for the performance of construction contracts, the EU has decided to specifically include engineering services and architecture on the list of services that cannot be provided by those to whom EU sanctions apply to Russia. And we see those services as being particularly relevant to the performance of construction contracts. As a third difference between the two regimes, or between two sets of regimes, is the fact that actually the EU and the UK sanctions will not apply extraterritorially. They will not apply to individuals and entities that are not European, that are not British, unless some part of the business is conducted in those territories. And you have heard previously from John and from Tal that especially through the regime of secondary sanctions, US sanctions laws will apply to non-US persons. And of course, with respect to US export controls, they will follow the item across the world, across international borders. And this is not something which will be the case with the regimes put in place by the EU and the UK. Finally, and I will end here, the enforcement of EU sanctions is also particular. It's also different than the enforcement in the US. Enforcement happens at national levels, which means that all 27 member states will have in their own domestic laws a definition of what actually is a sanctions violation and what punishments and what fines or imprisonment is prescribed for violations of those sanctions regimes. When you have 27 member states, when you have 27 different criminal law systems, it inevitably means that there will be some inconsistency between those member states. But if we can say that EU member states are learning from their mistakes, and we have seen certain movements towards more harmonization of how sanctions are enforced. It was in November, actually in late November last year, that the EU has decided to add violations of sanctions, violations of restrictive measures, as one of the EU crimes, which is comparable, for example, to the misuse of EU structural funds, to the Treaty on the Functioning of the EU. As all things at European or at EU level, it will take time for the EU to develop minimum rules on how sanctions are enforced and what minimum fines and sanctions are. But we are definitely going into that direction. I'm aware of the time. I will end here. Yasmin.
Thank you, Goran, for this very compact analysis of an indeed quite detailed matter. Just perhaps two follow-up issues I would like to have. Although you mentioned that in contradiction with the US approach to follow the item, the EU adopted the approach of the territorial jurisdiction. However, I cannot help myself wondering, what is the position about the use of currency? So, for example, when the transaction involves EU, the euro, or the pound by UK. How does EU approach to this?
Mm-hmm. So let's recall what was said about the US dollar denominated transactions, and Tal said that it actually does not automatically create US jurisdiction. However, usually US dollar denominated transactions include an involvement of a US financial institution in clearing those transactions. So if a US financial institution, a US bank is involved, there is US nexus. The same applies for transactions in euros or pounds. If transactions will involve a financial institution from the EU or from the UK, there will be a possibility, or actually nexus will exist. One other thing to note is that, of course, the euro is not the currency of all EU member states. So even if you have a transaction that is in Bulgarian, Romanian, Polish, Hungarian currency, although they're not the euro, but if they will involve a EU bank, meaning a Bulgarian or a Romanian bank, actually this might also implicate the EU's sanctions regime and the sanctions for the violation of those sanctions.
Thank you. Well, that's exactly a reply to the question, and perhaps a very significant question could be, what would you say as in terms of sanction, in terms of regulations, that would most highly likely to affect Turkish companies? What will be, the highlights for you?
Well, I think our audience is better placed to know what might sort of target them. But I think as we sort of mentioned, the question of road transport is something that was enacted. The prohibitions on road transport is something that was enacted by the EU very early on. And we've seen in the news that Turkey has taken certain measures actually to address those concerns through adopting, a workaround around the road transport prohibitions. And also, Aisha mentioned when she spoke about the different aspects of a construction project, that it might involve design, it might involve oversight over a certain project. So a ban on the provision of engineering services and a ban on export and import of certain raw materials into the EU is something that, looking at it from our perspective, is something that companies that are so close to Russia and that are involved in construction endeavors should be aware of.
Thank you. Thank you very much, Goran. And I think we should really pass to our last subtopic, which is about the enforcement of the sanctions and some practical tips. So I think I will give the floor to John. And
Great.
Yep. Thank you.
Great. Thanks so much. So we're going to talk about enforcement and risk areas. I'm going to talk a little bit about penalties, about the steps the U.S. takes in terms of ensuring that its sanctions are followed. But all is not lost. There are steps that Turkish companies can take to protect themselves. And we'll ask Aisha at the end to talk a little bit about steps companies can take to remain in compliance. So we can go to the first slide. So look, not surprisingly, there can be significant penalties involved in sanctions. There can be monetary penalties involved. You can be listed as a prohibited party, so therefore your access to the United States for a company would be denied or would be limited. There are also penalties that can be brought against individuals. Look, we've had clients who have been engaged in activities that were contrary to U.S. interests, that when they came to the United States, many people went through the visa line and were just got a stamp, and some people didn't. They got pulled over to a side room and they started to get questioned without their attorney present about their activities involved in prohibited activities. We know of one case where somebody decided to take their kids to Colorado to go skiing. and only the kids were allowed to go home. He was arrested because he was involved in sanctionable activity. This was involving Iran. So individuals can be targeted and penalties can apply to both companies and individuals. We'll go to the next slide. So an example of that is, just a few months ago in October of last year, there was a criminal indictment against European nationals and European entities for violating U.S. export controls by trying to ship a machine tool to Russia. And this is a good example where U.S. jurisdiction applied to the non-U.S. persons for activity that was outside the United States, but involved U.S. goods, software, or technology, and the U.S. asserted jurisdiction in that case. There was also a criminal settlement in 2022 against the U.S. company for filing false documentation regarding its exports to Russia. And the United States Bureau of Industry and Security, which is the Commerce Department agency responsible for enforcing U.S. export controls on dual-use items that are destined for Russia, they've put in place what we call temporary denial orders against more than 10 companies, most of them aviation companies, and generally that's a prelude to enforcement action. It takes some time for OFAC to work through its enforcement matters and work through its penalties. So we're only just starting to see the tip of the iceberg on Russia. If we have a follow-on panel in 2 or 3 years, we will probably spend most of our time talking about the new enforcement cases that have come up in the last couple of years. But even though OFAC generally takes a long time for enforcement, as well as the Bureau of Industry and Security at the Commerce Department, this is such an important priority for the United States, it's already occurring. So we're already starting to see some enforcement. And then we've also given some examples of other sanctions regimes that have had enforcement because of involvement of US goods, software, and technology, or US dollars were used to pay for transactions. They were routed through the US banking system. And remember, every single US bank is obligated under US law to check those transactions. So they'll be eyes and ears of the US government. We'll go on to the next slide, please. One of the things that we worry about, not only from is whether we have monetary penalties, but also whether there could be access denied or restricted to the US market. And the Undersecretary of Commerce, who's the senior most official of the Commerce Department responsible for enforcing export controls on Russia, has noted that if a non-US company violates US laws, his general reaction would be to put them on the entity list. What's the entity list? The entity list is a list of companies and individuals that, in order to get any access to US origin technology, goods, software, et cetera, so a pencil, for example, they might have to get a license in order to do that. And in many cases, those licenses will be denied. And so he's very specifically signaling that if a non-US company violates US export control laws, they're going to take action. You could also lose access to the US banking system if OFAC takes an enforcement action. We'll take the next slide, please. So what are red flags? Look, the reason all of you are on this seminar today is because you're really focused on compliance and what we would say in the United States is doing the right thing, of taking activities, taking actions to make sure that to the extent that the US law applies, or as Garan noted, EU or UK law applies, that you're
John, I think we lost the sound for a moment. Not sure if.
Yes, I think I have the same problem. John, I'm very sorry. John, I think we cannot hear you. And you don't seem muted. I don't know why it happened. Can it be maybe your headphones? I'm not sure.
While John gets his sound back, maybe we could go to the next slide. I think, Aisha, if you wanted to cover that, and then we can go back to some of the red flags, which are listed on that slide.
Sure. I'll address the steps to take to remain in compliance. The first most important step is to implement trade sanctions and export controls program within the company. Certain companies, big sophisticated companies already have it in Turkey based on my experience, but certain companies do not have it. OFAC strongly encourages organizations subject to US jurisdiction as well as foreign entities that conduct business in or with the United States, US persons or using US origin goods or services to employ a risk-based approach to sanctions compliance by developing, implementing, and routinely updating a sanctions compliance program. We hear that a lot. That's usually the compliance departments of the companies handling it. And it's very, very important to be compliant with the sanctions regimes. Make sure that you screen all transactions against applicable prohibited lists. That's very important. Screen your third parties. Your third parties are your customers, your suppliers, your subcontractors, all parties in the supply chain, your intermediaries, your counterparties, and definitely your banks and the banks of all other third parties. So make sure you screen all of them. Screening meaning you check whether they are in any of the prohibited lists. It's really important to understand how to screen all transactions against the applicable prohibited lists. Even if you have a compliance program in place, try to do your screening perfectly. There have been cases where OFAC issued penalties to parties because when they do the screening, they searched O period, O period, O period instead of O, or they put 4 instead of O in the company title. So that is not going to be a defense if you missed it. It's really important to understand how you do the screening and carry out in a way that is sufficient to catch the prohibited parties. Of course, consider the 50% rules. Make sure you check the owners and do everything to catch the prohibited entities. Although intent is not required for the US to determine a violation has occurred. So even though you do everything you can, you may still be liable. But if you all this, if you try using screening softwares, especially use the physiologic to catch all the mistakes in O period, O period, O period. If you do all this, OFAC will consider it as a mitigating factor in an enforcement case. So it won't be a defense, but it may still decrease the penalty. Determine if your transaction is subject to US, UK, EU, or other jurisdictions for sanctions or export control laws. So make sure to check your geographic locations of the company. If your company or your transaction is not subject to jurisdiction for sanctions or export control laws, still make sure to assess risk for US secondary sanctions, which we talked about. It arises even though there is no US jurisdiction. It's a serious risk if the activity supports directly or indirectly Russian war effort. Make sure to evaluate whether there is US, EU, UK content in products to be transferred to Russia, or if the items transferred were manufactured with US technology, plant, or equipment. The product itself may not be a controlled item, but if the product was manufactured in a plant, which was built with a US-based technology, the manufacturing plant itself, then it may still be subject to US export control law. So it's pretty sophisticated area where you need to be really careful about what you are transferring. So make sure to check your products and service offerings. And finally, I would say consider whether contractual clauses are in place to protect against non-performance in the event the planned work becomes sanctionable. If the time allows, we can talk a little bit more about the relevant contractual provisions, which may help the parties to navigate the risks and uncertainties. So I leave the floor to you, Yasemin.
If I may jump in, can I check if John had his voice back?
Yes, hopefully I have my voice back and you can hear me now. I'm not sure exactly what happened, but as we know, the US government watches over everything. So maybe
Okay, so if we can just go through your slides, and then I will definitely come back to the last point, Ayşenur, because I already have questions for John and for you. So if we can finish this, and we can take with the questions once we are finished.
Sure. So hopefully you can all hear me now. So we talked very briefly about red flags. The U.S. expects companies to do due diligence. Ayesha has outlined how you do the due diligence, which is very important. And some of the things you look for are cases, if you're dealing with third parties, where they're obfuscating or trying to hide the connection with Russian sanctions, with Russian prohibited owners. Oftentimes you have shell companies involved, or you have transactions that are frankly too good to be true. And there's a reason they're too good to be true, because they're prohibited. And so you basically want to go through the steps that Ayesha outlined in terms of making sure that you stay in compliance. And all of you who are very attentive in this industry, look, you know when something's amiss, and the United States government expects companies to follow up on their suspicions. Next slide. So there is possibility for licensing. Licensing is permitted under certain circumstances. It's very difficult. The US was certainly going to encourage activities that have humanitarian overtones, authorizations either under what we call general licenses, you don't have to apply for it, but transactions involving food, medicine, or medical products. There's not an exception though for construction. That's something that the US would actually look at very, very carefully in terms of its sanctions. Export licenses are available for Russia in some cases. In very limited cases, the U.S. may decide it's in its U.S. interest to actually authorize activities, but in most cases, it's something that's going to be denied. And so that's something that goes back again to what Ayesha outlined, that the need to do very comprehensive reviews. And particularly, in the construction industry, we worry about any transfers of US origin software and technology, any of your CAD/CAM engineering support, computers, software. In addition, as Tal mentioned earlier, construction equipment that is US origin. Basically anything that's coming from the US, you're going to have to assess whether it's restricted. Not everything is restricted. The lowest level of US export control is permitted to go to Russia, even if there's a US connection, so long as that's not being used to support the Russian military or construction activities involving the Russian military. And look, I think the US is going to be very, very specifically focused on any companies that are helping the Russian military in any areas of work. And construction companies is one that we would expect the US to have a very, very strong focus on. It's not prohibited to do construction in Russia. US companies can do construction in Russia. They just can't do activities that would support the war effort. We can go to the next slide. So I think we've basically caught up to where Ayesha has already gone through the compliance steps. So maybe we'll now turn to back to Yasmin for any observations or questions that you have.
Yes, thank you very much, John. So I indeed have a couple of them, and we still have 15 minutes. I hope we will have ample time to discuss. So perhaps one of the probably quite crucial issues would relate to equipment, because as you know, although not directly construction activity itself, import, provision, or planning of equipment, the supply chain for contractors attempting to do business in Russia will be quite important. And as we all know, and I think Tal also gave examples of bulldozers and heavy construction equipment. Actually, a lot of them come from US, or at least with, as you say, some engineering done by US firms, and at least some components of them are US origin. And also referring to the principle of follow the item, how does it actually work? For example, I will just, try to understand. A Turkish company, a non-US company, imports some construction equipment and becomes the owner of that equipment, and the equipment is in Turkey. Would the understanding be correct to say that even if the ownership, changed, because the engineering and the product origin did not change, resale of that item would somehow be still relevant if the resale will concern activities in Russia. So, to what extent we will be following the item. And also, in this example, the equipment, the item is in Turkey, intending to go to Russia. But what would happen to equipment already in Russia? Because, we know for sure that a lot of construction sites were affected. Some of them were terminated. Some of them are still ongoing with difficulties. What about using the equipment that are left for one reason or the other in Russia, in some construction sites to other sites for use of them in other projects? So
great. So maybe I can follow up on this. So
yeah.
the first thing is I think you've actually outlined it very well. In many cases, we would think, like, once you own it, you own it. You can do with it what you want. And the US government just has a different view. We can say whether that's aggressive, whether that's extraterritorial, but it's clear that's what their view is. And so if you have equipment that originates in the United States, or that is from a US company, maybe manufactured outside of the United States, if it has more than a certain amount of US content, it's still going to be subject to controls. So if it comes from the United States, it's US origin. If it comes from outside the United States, you basically need to ask the seller of that, is this something that is subject to the US controls? It might be subject to EU or UK controls, but it's usually the US that has the extraterritorial application. Now, things that were sent to Russia before the sanctions went in place to a particular entity in Russia for a particular use, they're allowed to keep using it for that purpose. The US is not going to restrict that. But following up on your question, what if you're moving it to a different site, a different entity? It's very fact specific, but it's highly likely that that would be restricted. In other words, that is something that the US would want to impose controls on. One way you can think of it is, if the restriction would apply to a direct transfer to Russia, it probably applies for a transfer within Russia. There are some exceptions for that. So it's not always the case. You have to look at it very, very specifically. But the US wants to accomplish a foreign policy objective, which is to change Russian behavior. And the way that they can do that is putting pressure on Russia. One of the targets that they can do to put pressure on Russia is US companies, Turkish companies, Middle Eastern companies, European companies that deal with US origin goods, software, and technology. It's a lever that they can use.
Yeah, perfectly understood. Goran, would your reply from EU perspective change for the same question?
It will be somewhat different, but then again, all restrictions can be applicable to the same situation. So if there is a transaction, or if there is something that a company wishes to do, it is possible that at the same time multiple sanctions regimes are triggered. So a company would need to make sure that even though something may be allowed under the EU regime, it may not be allowed under the US regime. So you will need to make sure that it in the conduct in its conduct that it actually respects all the regimes that may be applicable in that situation.
Okay, thank you very much. And now I really want to turn on the contractual issues, because this is another matter that, early 2022, we were really left a little bit unplanned because the contracts already executed did not have, mechanisms to deal with the situation, or let's say sufficient mechanisms. We needed to resort to a lot of interpretation, which is, usually the last resort. So, and Ayşenur, you were just talking about that in your last slide. What could be done in terms of dealing with the risk analysis, or, let's say, keeping the companies out of the risk in terms of the contractual mechanisms? Because as I understand, not only we can be subject of sanctions directly due to regulations, but also we can be left contractually exposed as well, either directly because the contract is somehow, touching upon sanctionable matters, or by your out of contract act, for example, by a purchase of a product, and by reselling it, you may be in breach of your previous contract. So how to deal with these contractual mechanisms in the best way possible? Again, for everybody, but whoever wants to reply.
I can maybe first start and then let John and Tal and Goran, if they have comments, they can add. It's very understandable that the companies want to comply with their contracts, perform their obligations in accordance with the contracts, but there are cases when the companies simply cannot perform, or it's just too difficult for them to perform. Based on the practice, what we see in the practice, both actually happened. So it's it would be very important to look into the contract provisions very carefully. There may be certain provisions which may be helpful because all the sanctions regime caused significant disruption in the supply chain. That just added burden of additional time and cost for the contractors. So, and the prices went up significantly. In that sense, price escalation provisions may be relevant to consider, to look into. If there are no price escalation provisions, there may be other provisions that shift the risk between the parties and which should be considered. Contracts can contain force majeure provisions, which may allow claims for extension of time and or price adjustment when an event causing delay to the completion of the project occurs, but which was not reasonably contemplated by the parties when the contract was entered into. So the question will arise whether the contract was signed before the sanctions, before the crisis, or not, but there may be some mechanism there. Also important to check, I think, the act of government related provisions, especially the definitions. I've come across with contracts where the contracts are governed by, let's say, like Russian law or Turkish law, but the act of government definition is so broad that includes acts of US government or EU countries' governments. So it's a good idea to look at those definitions to see whether there may be a way for the companies to excuse their performance. What else I can add? Those provisions may also provide tools for the contractors to claim additional cost and time, depending on the facts. It's very facts-based question. Also, where the contract is yet to be signed, I think it's, for the future projects, there may still be time for parties to reassess the contractual provisions to ensure certainty in this ever-changing economic climate. For future contracts, I think it's highly important that the parties take into account the ongoing sanctions and export controls based on their equipment and materials they have to use in their performance. And they should determine their risks and price their bids accordingly. Those are the major provisions which came to my mind. Anything else, John, Tal, Goran, you may add?
Nothing from my standpoint.
I can maybe only comment. It's quite important what you say about, for example, price escalation related provisions, because they are quite okay if if not commercially already agreed, quite unusual in contracts in Russia, let's say, already existing contracts. And also, as I said, we were really caught unplanned in 2022, early 2022, because if I recall correctly, I'm not a Russian lawyer, of course, there is not much hardship-related mandatory provision under Russian law, so that you can actually lodge the argument that your performance became impossible. So on one hand, you are bound by your contractual obligations. On the other hand, you are bound by the sanction regime. And this is what I recall is really you are innocent, but you are being punished by two separate parties at the same time. So that was also in my mind quite important to understand the contractual risk assessment as well for contractors, not only for the main construction contracts, but also for supply chain, for the downstream subcontracts and supply contracts and so on. So that was one thing. And the second thing, maybe for the existing contracts, there was an element of unforeseeability. So you could kind of push your way from that end. But now there is no such thing. Everything is foreseeable. You know everything. And it's even probably a heavier burden as a prudent merchant to actually, when you assess your contract, to enter into such contracts is a heavier burden now than in the past. There was another question, but it's related to the logistics, so I'm not raising it with you. And let me just reply it from here. Yes, the presentation will be distributed by SEL Turkey to all the participants of the workshop. And I think we are extremely on time. I thank you very much for all your efforts and for being on time as well. I think it was a very useful discussion. And just as a note for future, we usually follow up this sort of webinars with either more detailed or with a specifically different kind of subject as well, if the audience requests organization of such topic as a webinar. So I thank you again for coming and discussing all these matters with us, replying all the questions at the same time, and we hope to see you again in future.
Thank you for having us. Thank you.
Thanks.